Okay, hi everybody. My name is Richard.lesperance. I go by the name of my man Richard. Welcome to a better lifestyle. Today I have the pleasure to have Richard Gearhart. Richard is an award-winning speaker. He's also a TV network expert guest. Also, he has a nationally syndicated radio. He's a radio show host and also he's an attorney. So I hope I didn't mess that up. So
No, it's pretty good, Richard. Thanks for
great,
the introduction. I appreciate it.
great, great. So I'm gonna dive in right into the topic because we're gonna be talking a little bit about IP, so intellectual property. So sometimes there's things that people are not aware about when we talk about intellectual property. So we gotta dive into some questions in regards to that. So, Richard, what are the main things that people have to uh, think about when creating an IP and protecting their idea?
Well, that's a great question, Richard. And it's just really a few couple of basic things that people need to keep in mind. It's especially important when you're starting a business. So, this message is going out there to all those entrepreneurs who are starting a business or thinking about starting a business. But number one is that you want to make sure that you do uh, searching before you start your business. And by that, I mean, if you are going to be using a special brand name for your business, you want to make sure that somebody else doesn't already own the rights to that brand name. And the way that happens is through a trademark search. So trademarks protect company names and they also protect brands. So, for example, one of the most famous brands is Coca-Cola. And so the Coca-Cola bottling company has a trademark on the terms Coca-Cola, and they use it in their business name, but they also use it to name their products as well, right? And so before you start a company, you want to make sure that the name is available. And so that happens through a trademark search. Now, sometimes people get a little confused between registering their name with the state. They typically will form a company. Lots of times it's an LLC, and they'll apply to the state government for a business name. That's different from a trademark. Just because you can register your business name doesn't mean that you're automatically allowed to use that name for your business. You also have to do a trademark search. And so that's, very important to do up front. You want to make sure that if you're buying a URL for your business, the domain name for your website, that is also available from a trademark perspective. Because if somebody has, let's say you start a new business called Stop Clowning Around. Let's just say, for example, that you want to start a business for circus performers who want to get out of the circus business. And so you're going to call your business Stop Clowning Around, right? Well, you can maybe get that URL and that domain name, but somebody else may already have the trademark on that. So you want to do a trademark search early in the process. Normally, they're not that expensive. They range in price, from $500 to $1,000, depending on the person that you use. Usually, it's a law firm, and this way you can be sure that you're not going to be infringing somebody else's name. So, uh, so that's one really important thing for new business owners.
Are there, I think as I had found out through another lawyer, I think there are some free searches, free places that you could search for. I have the website, but I forgot what was the name of the website to see if there's I don't know if that's trustworthy or not, but it was a lawyer that said that place. So I had went and search, but it was free. But I want to know if that's trustworthy.
So that's a great question. I mean, usually before you start, you would want to search on the internet just to see if anybody else has the name. That's easy enough. And then if you want to take it to another step, you can go to the U.S. Patent and Trademark Office, and the URL domain name for that is uspto.gov.
Okay, I think it's that one.
And then you can do your search there, and you can actually look for registered trademarks. It is free. Some people find that website kind of complicated to use, and part of the search process is making sure that somebody doesn't have a similar name. So um, it, so you can be infringing a trademark, somebody else's trademark, even if you're not using exactly the same, exactly the same name. And so if you can afford it, it's much better to have a patent or intellectual property professional, a trademark professional do the search with you, because um, it's you can be infringing a trademark even if it's not one-to-one identical. So, for example, if you had a trademark like society, society sandwiches, um, you may want to trademark my society sandwiches, right? But even though the words are different and the trademarks are the words are different, a trademark on my society sandwiches would be infringing somebody else's trademark for society sandwiches. And so there's a lot of differences and nuances in the trademark law that a professional can, help you with, and shield you from a lot of the risk that's associated with that. But if you're on a budget, you can go to the U.S. Trademark Office website, that's uspto.gov, and you could look there. And that's another way to approach it, but you may take a little bit more risk that you could get in trouble down the road.
So what happens if you were talking if they're a little bit similar? What happens then?
Well, as it depends on a lot of things. It depends on are the marks being used in the same streams of commerce? Are they being used for the same type of goods or services? So that's one analysis that we do. We check to make sure that the 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 problematic trademark is still in force. Sometimes the marks go abandoned and they're not a problem. Um, if it's the same goods and the mark is still in force, then we might suggest a modification to your mark, or we might suggest you adopt another mark. So, one of the advantages of doing a search early in the process is that you don't necessarily have a lot of investment in the brand. So, you haven't spent a lot of money on advertising or packaging or on a website. And it's a lot easier to change the name to something safe early in the process rather than waiting 2 or 3 years and then finding out maybe you have a problem, and now you have to change everything and it becomes much more difficult and much more expensive. So it's best always to try to do this early in the business stage if you can, and make sure that you're on solid ground. So we have a lot of issues with clients where they didn't do a search, and they come back, um, you know 2 or 3 or 5 years into their business, and somebody else with a trademark uh, that predates theirs notices, and they send them a cease and desist letter. We had one client where we did a search for them, and we found a trademark that we thought was going to be problematic. It was differed only by a letter. So they had their name, and it was Then we found another mark that was for the same services. It differed by one letter. And we said, this is a risk. Well, the client said, no, I really like the name. I'm going to go ahead anyway. Well, 5 years later, that company came back to them and they said, stop using your brand. Well, by this time, the guy was a $30 million company and he was like out there all over the place and he didn't want to have to change his name. And we ended up getting into a big litigation with them. And, he spent like $300,000 in legal fees, defending his name. And eventually we settled the case on favorable terms. But if he had known ahead of time and changed the name, he would have saved himself a lot of money. And so that's what happens if you don't do the search early on, and then you run the risk that you're going to have a problem down the road.
Now, besides the doing a trademark for your name and your logo, recently I know you could trademark a lot of things, and I was surprised. I was listening to someone in the music industry, and they were talking about Michael Jackson. I'm not sure if I'm saying the right thing, but he was saying that he had trademarked. There's a move that he was making in his show that was trademarked. So, what can we trademark and what can we not trademark? Because I think there's a lot of things. It was simply a move that he was doing like on stage, and he said that was trademark. So I was pretty surprised about that.
Well, you can get trademarks on a lot of, yeah, I'd be kind of surprised about that too. Although I never rule out anything when it comes to Michael Jackson, right? So, but you can trademark colors, you can trademark scents, um, you can trademark something called trade dress, and that's the way something looks. So you can protect like the look of a product either with a design patent, and and sometimes you can even protect it with a trademark. So, for example, Apple computer has protected the look of their stores with trademarks, and that's through something called trade dress. And if you can show that the brand is so distinctive that people recognize the store based on how it's decorated and how it's constructed and the colors and the materials and everything. They recognize that and it's distinctive, then you can get a trademark on that. Dance moves, I guess it's possible if it's if
I
it's
think it was I think it was something he was doing, like he was leading or something like that. I don't remember exactly, so I'm not sure, but he was saying that there was something that he did that was trademarked. So I was pretty surprised. So I don't know exactly what was the move or what was the thing, but
I mean, it's possible if you can show, distinctiveness. That's one thing. For example, um, the Owens Corning fiberglass is pink, right? And that's the insulation that goes on the inside of houses, under the walls of houses. Owens Corning has been selling this pink fiberglass for a long, long time, and they became famous because the the color was really different at the time they launched it, and so they were able to trademark the color pink for insulation, building insulation. And John Deere, the truck, I guess it's the tractor maker and heavy equipment maker, they have green and yellow tractors, bright green and bright yellow, and they were able to trademark that color scheme. So anybody who uses bright green and yellow for their tractor could get in trouble from John Deere, right? And so it's pretty interesting all of the different things that you can trademark. But most people they stick with their name, and as you mentioned, Richard, the logo. Those are the starting points. Usually trademarking the other stuff comes down the line. And uh, when you have a better developed business, there are also it's also possible to trademark uh, certain like a jingle. So um, the NBC used to have a jingle that went bum bum bum, right? And they have a trademark on that. And then I guess it's, you know, 20th Century Fox that has this lion that's roaring, or maybe that's Metro Golden Mayer. I think that's the name of the production company. But when you see a movie and you see that lion making that roar sound, um, that sounds also trademark. So it's it's pretty funky.
So how would you know if it's possible to do a trademark on what you think is original or whatever? How would you know?
Well, I mean, that's you would want to contact if you're unsure about it, you would want to contact the intellectual property attorney, right? And some things in the creative space like this are also protected by copyright. So that's another option, right? And copyright is different from trademark. Copyright protects original works of expression, and so it protects music, films, uh, books, written manuscripts, plays. You can also protect architecture with copyright, paintings. All of the creative arts can be protected with copyright in some way. And that's different than trademark. And one of the differences is the legal standards for enforcing copyrights versus trademarks. And another piece of it too is that copyrights are free. They arise just when you create the work. So when you go for a trademark, if you want to file a trademark registration, at a minimum, there's a government fee to pay, and you would typically hire an attorney to help you with the application. Um, you could also file it yourself. If you want to file the trademark yourself, you can call the trademark office, and they have people there that can help you, and they won't charge you. But if you, a lot of people have attorneys handling the trademark for them because there's some advantages to that. Copyrights, on the other hand, are free, and so they arise automatically when you create the work. And it is possible to register a copyright. You can go to the Library of Congress and fill out a two-page form, and then you can register your copyright there. And that has advantages to doing that, but you don't have to do that. So,
In regards to the fees for the trademark, is it possible, because when I was doing some research, is it, correct me if I'm wrong, if you don't use the trademark, you could lose it after a certain period of time? Is that true when it comes to renewal or not using it?
so it sounds like you already know a lot about this, Richard. Um, yeah, so after 5 years, you have to show the trademark office that you're using the mark in commerce. And you would do that by submitting specimens. So you submit specimens to the trademark office, and maybe it's an invoice or a brochure or a screenshot from your website. And they examine the specimens, and if they believe that you're using the mark properly, then they will renew the trademark application. And so the first time it's a 5 year period, 5 years after the trademark is initially granted, you have to submit the statement of use. And then after that, it's every 10 years. And what's important to know is that you need to show use for all of the goods that are described in the trademark registration. So if you write a trademark registration that says t-shirts, hats, and umbrellas, then at the 5 year mark, you're using it for those goods, t-shirts, hats, and umbrellas. At the 5 year mark, you have to show that you're using the mark for t-shirts, hats, and umbrellas. So you need to show from your website or, from your invoice or from your advertising that you're using the marks for each one of those goods. And if you're not, then to cancel out the item from your registration. And so one of the benefits of having an attorney involved is that they will know how to draft the statement of goods in a way that you can maintain the registration over a broad spectrum of goods. So, for example, maybe we would just say clothing and accessories. So that way, if you just show up for t-shirts, that fits the broad definition of clothing and accessories. If you get very specific about it, then you have to show it for each type of good that you put in your registration. So that's why hiring an attorney can be an advantage if you can afford it, because they'll write the application in a way that when it comes up for renewal in 5 years, you get to maintain the full scope of your protection.
You were
Now,
talking, yeah, you were gonna say?
no, I just ended the sentence there. That's
Okay.
all.
In regards to, because you were talking about t-shirts, I wanted to ask a question about that. If you're doing t-shirts, let's say for sale, and you're using like generic names, let's say you're printing a white t-shirt and it says, I'm the best. How does those things work when you use generic words?
Well, registering that as a word mark um, could be tough because you're right. It's considered could be considered descriptive by the trademark office. So you can certainly print a T-shirt that says "I'm the best," but if it's too descriptive, then the trademark office thinks, well, that's a phrase that everybody should be able to use. And so people should be able to use that phrase without infringing somebody else's trademark. So in that case, they might consider it descriptive and they might reject the mark.
No, but I'm
Now,
not, excuse me for cutting you off. I'm not saying like to trademark it. I'm just saying like if someone is doing it but without doing a trademark, will they get in trouble or that's what I was referring to.
well, yeah, I mean, probably not. You can put anything you want on a t-shirt. Um, if you start putting like pro football team, names and logos on there, I mean, if somebody owns the trademark for what you're putting on the shirt, then you could get in trouble, right? So the the NHL or the NBA or NHL, they're really protective of their logos and team names, players' names. So you can't put anything you want on a T-shirt. But if it's something generic like "I'm the best," yeah, you can. I'm sure you could use that. Um, I mean, I think and I'm not even sure that for some stuff it's even worth doing a trademark search. Um, but I would check online at least, to make sure to see if somebody else is using it. But if it's generic, like you say, should be no problem.
So another thing, so if someone is in the US and they want to trademark something, whatever it's a name or a logo, or let's say it's a name, let's say they're in the US. Is it one trademark? Does it apply to all states, or they have to do it's for each state is different?
Oh, that's a great question, Richard. So we've been talking about federal trademarks. And so federal trademarks apply to all 50 states. If you want to protect something, say in Canada, then you would need to file a separate trademark registration there. Or if you wanted to file protect something in Europe, you would have to file a European trademark application. So trademarks in general are country specific, but it's also possible to file for a state trademark. So and state trademarks are less expensive than federal trademarks. For example, I'm in New Jersey. If I wanted to protect something in New Jersey, I can file a trademark registration with the state of New Jersey. It wouldn't protect me in Philadelphia or Pennsylvania. It wouldn't protect me in Ohio, but it would give me protection in New Jersey. And those applications tend to be less expensive than the federal trademark registrations. So if you're a local business and you don't want to shell out the money for a federal registration, or maybe you don't do interstate commerce, then you may not be able to get a federal trademark registration, but you can always get a state one. And so if you're a local business, getting a state trademark registration could be a good idea.
So if you're doing it on a federal level, let's say someone is based in the US, but they didn't do it in Canada. What happens if someone from Canada sees someone in the US using a name that is similar or exact name?
Well, um, so if if the business owner is in Canada and they filed a mark in Canada but not the U.S., then they would be able to they wouldn't have any rights to stop a U.S. person from using their name. So uh, and so that's something you keep in mind if you're doing business internationally or you think your product's going to be international is to consider the international protections. Now, if it's a U.S. business owner and they have a United States federal trademark and the Canadian company imports products using that U.S. company's name, then the U.S. company could stop the Canadian company from selling in the United States under that name. But they couldn't stop the Canadian company from selling the same named products in Canada. So it's if somebody imports something, so suppose like you have a trademark and there's a company in China, there's a lot of manufacturing there going on there. They decide to rip you off and they create packaging that's similar to yours and they make it in China, they send it to the US, then you would be able to use your US trademark against them in the US and in theory stop them here. But you couldn't stop the Chinese company from selling the goods, say, to Russia or to Brazil, for example, unless you had trademarks in those countries too.
Okay. Last words in regards to everything we talked about.
I think, just go back to what I said earlier. If you're an entrepreneur and you're starting a business, the best thing you can do is check before you adopt a business name, before you register it with the state, before you buy a URL. It's so much easier to change your name in the beginning, and it won't cost you much compared to running into trouble, down the road. Um, we didn't talk about patents, but patents protect ideas, technology, new products. And if you want to launch a new product, you also have to consider doing a patent search for the same reason. because somebody else might have a patent that covers your product. So whether you're launching a new product or you're launching a new brand, you should search early on to make sure that you've got a clear pathway to success.
Yeah, and there's other stuff too, trade secrets and all that. So I don't know, maybe we'll do another episode on that. Where can people learn more about you and follow you?
So I'm on LinkedIn, Richard Gearhart, and I'm also available through the firm's website. That's gearhartlaw.com, and that's spelled GearHartlaw.com. And we offer free consultations if you have questions about your intellectual property. We'd be happy to talk to you. So
Okay.
reach out if you'd like more information.